Hi, I'm Jim Wesco. I'm the chair of the Weber Gallagher Commercial Transportation Department, and I'm here today to give you an update on a recent Third Circuit ruling involving broker liability for cargo claims. Recently, the Court of Appeals for the Third Circuit affirmed a lower court's ruling regarding the liability of an interstate transportation property broker under federal law, even though brokers are not typically liable for such damages under federal law. The ruling is consistent with rulings in other federal circuits and is instructive as to how brokers represent their services to their shipper clients. The case is Trig Insurance versus C.H. Robinson, and in that case, the court ruled that a broker could indeed be liable for the loss of cargo even though it did not transport the shipment. The case involved a load of chocolate liqueur bottles that melted during transport. The shipper hired C.H. Robinson to facilitate the shipment, and when it went bad, the shipper's insurer filed suit against Robinson. Robinson argued that it could not be liable for the loss since it acted only as the broker for the shipment. Under federal transportation laws, carriers and not brokers are liable for loss or damage to cargo in interstate transportation pursuant to the Carmack Amendment. So the issue before the court was whether Robinson held itself out as a carrier, thus exposing itself to liability under Carmack, or was it merely acting as a broker? The court noted that transportation as defined by federal statute entails more than merely picking up shipments and delivering them to another location. On the contrary, transportation includes services related to transportation, including presumably arranging for it. The key issue is whether Robinson had legally bound itself to transport the goods by accepting responsibility for the delivery, as opposed to merely agreeing to locate and hire a third-party carrier to make the delivery. The court found persuasive the evidence that Robinson told the shipper that it would transport the goods in a seamless manner and from start to finish, and that Robinson did not ever tell the shipper that it was acting as a broker and it didn't have federally issued motor carrier authority. The court also noted that the bill of lading and packing list both identified Robinson as the carrier. In addition, Robinson's invoice to the shipper included line haul charges and fuel charges, consistent with an entity that was acting as a carrier. In short, the court found that since Robinson had accepted responsibility for transporting the shipment and not merely arranged for the transportation, it was a carrier and not merely a broker. The Trig Insurance ruling follows a line of similar cases in the Third and Second Circuits where brokers acting like carriers were treated as such. The ruling can be compared with other recent rulings in the District of New Jersey where a broker was not found liable as a carrier under Carmack where no such representations were made. So the message to brokers is clear. Be careful what you promise as you will be held accountable.